Hello friends, how are you doing today? Let's talk about the process. Filing for bankruptcy in India involves a detailed process and considerations. Here is a more detailed explanation of the qualification criteria, reasons, pros, cons. Procedure, steps, relevant sections, and additional information. Qualification for bankruptcy. Individuals. To file for bankruptcy as an individual, you must be a debtor with a minimum debt amount of 500 rupees or more. You must also be insolvent, meaning you are unable to pay your debts as they become due. Companies. A company can file for bankruptcy if it is unable to repay its debts and is deemed insolvent. Reasons for bankruptcy. Financial insolvency. Bankruptcy can be filed when an individual or a company is unable to meet their financial obligations and repay debts. Business failure. Companies may file for bankruptcy due to business failure, loss, lack of profitability, or insurmountable debt. Pros of bankruptcy. Debt discharge. Bankruptcy provides a legal framework to eliminate or reduce debts through a court-approved plan. Moratorium period. Once bankruptcy is filed, creditors cannot initiate or continue legal proceedings to recover debts during the moratorium period. Fresh start. Bankruptcy offers individuals or businesses a chance to start anew financially by relieving the burden of overwhelming debt. Debt restructuring. Bankruptcy may allow for the restructuring of debts, creating a more manageable repayment plan. Cons of bankruptcy. Credit impact. Bankruptcy has a significant negative impact on credit scores and creditworthiness, making it challenging to secure future credit. Public record. Bankruptcy filings become public records, which may adversely affect personal or business reputation. Asset liquidation. In certain cases, assets may be liquidated or sold to repay creditors, including personal or business property. Procedure and steps to file bankruptcy. Consultation. Seek guidance from a qualified bankruptcy lawyer to understand the process and assess your eligibility for bankruptcy. Documentation. Gather and organize all relevant financial records, debt details, and asset information to support your bankruptcy filing. Filing the petition. Prepare and file a bankruptcy petition in the relevant Debt Recovery Tribunal, DRT, or National Company Law Tribunal, NCLT, as per the applicable law. Include necessary supporting documents, such as financial statements and creditor details. Appointment of insolvency professional. The tribunal may appoint an insolvency professional, IP, to oversee the bankruptcy proceedings, manage the debtor's assets, and represent their interests. Creditor claims. Creditors are given a specified time frame to submit their claims against the debtor's assets. Debt resolution plan. The IP, in consultation with the debtor, formulates a debt resolution plan, which may involve debt restructuring, repayment, or liquidation of assets. Approval and implementation. The proposed debt resolution plan is submitted to the relevant tribunal for approval. If approved, the plan is implemented under the supervision of the IP. Relevant sections. Individuals. Bankruptcy proceedings for individuals are governed by the Insolvency and Bankruptcy Code, 2016. Relevant sections include Section 94 to 187. Companies. Bankruptcy proceedings for companies are also governed by the Insolvency and Bankruptcy Code, 2016. Relevant sections include Section 4 to 59. Additional information. Legal counsel. It is highly recommended to seek the assistance of a qualified bankruptcy lawyer who can guide you through the process and represent your interests effectively. Disclosure of assets. It is essential to disclose all assets and liabilities accurately during the bankruptcy proceedings to ensure a fair and transparent resolution. Compliance. Cooperate with the IP and comply with all legal requirements and directives throughout the bankruptcy process. Example. Shrey, a young professional, finds himself overwhelmed by mounting debts that he is unable to repay. After exploring various options, he decides to pursue bankruptcy as a means to resolve his financial situation. Shrey meets the qualification criteria, as his debts exceed 500 rupees, and he is insolvent. To navigate the complex process, Shrey seeks the guidance of a bankruptcy lawyer. Together, they gather all the necessary financial records, debt details, and asset information. They meticulously prepare the bankruptcy petition, ensuring the inclusion of supporting documents, and file it with the appropriate Debt Recovery Tribunal (DRT). Upon filing, the tribunal appoints an insolvency professional (IP) to oversee the proceedings. Shrey's creditors are given a specified period to submit their claims against his assets. Working closely with the IP, Shrey develops a comprehensive debt resolution plan. The plan includes debt restructuring, which aims to renegotiate terms with creditors and establish a manageable repayment schedule for Shrey. This process enables him to work towards financial stability while providing fair treatment to his creditors. Once the debt resolution plan is finalized, it is submitted to the tribunal for approval. The tribunal carefully reviews the plan, considering its feasibility and compliance with relevant laws. Upon approval, the plan is implemented under the diligent supervision of the IP. Shrey acknowledges the potential challenges that come with bankruptcy. He understands that his credit score will be negatively impacted, making it challenging to secure future credit. Additionally, he is aware that his bankruptcy filing will become a matter of public record. Nevertheless, Shrey remains optimistic about the fresh start that bankruptcy can offer. He is committed to fulfilling all legal requirements and directives, cooperating fully with the IP throughout the process. To know more, please like, share, and subscribe our channel.